Good afternoon. My name is Lonnie Brown. I'm Associate Dean for Academic Affairs at the Law School, and it's my pleasure to welcome you to our 112th Sibley Lecture. This preeminent lecture series honors the memory of John A. Sibley, a 1911 graduate of the law school. During his long life, Mr. Sibley distinguished himself as a lawyer, banker, and unparalleled supporter of the university. After attaining great prominence as an attorney with the highly respected Atlanta law firm of King & Spalding, he became general counsel to the Coca-Cola Company, and later the chairman of the board and president of Trust Company of Georgia, now known as SunTrust. Throughout his enviable career, Mr. Sibley was always a devoted and influential alumnus of the university, serving as the president of the UGA Alumni Association and playing a major role in the capital campaign that led to the construction of the law school's main building, Harold Hirsch Hall. In addition, he was integral to the law school's effort to obtain full accreditation in the 1930s. Mr. Sibley is also known for having chaired, during the early 1960s, the General Assembly Committee on Schools, which was tasked with the difficult assignment of ascertaining public sentiment regarding a federal court order that mandated desegregation of Georgia public schools. The so-called Sibley Commission is credited with laying the foundation for ultimately ending massive resistance to desegregation within the state and helping then-Governor Ernest Vandiver avoid a showdown with the federal government. Mr. Sibley remained an active business and civic leader for many more years and passed away in 1986 at the venerable age of 98. The lecture series in his honor has a history that is as rich and impressive as his life. It began in 1964 and over the years has attracted such academic luminaries as Charles Allen Wright, John Hart Ely, Grant Gilmore, and Stanley Fish, as well as 4 Supreme Court justices: Chief Justice Earl Warren, Justice Harry Blackmun, Justice Ruth Bader Ginsburg, and Justice Antonin Scalia. The 2 annual Sibley Lectures are underwritten by the Atlanta-based Loredence Foundation, currently headed by Robert Edge, a senior partner in the law firm of Alston and Bird. We are incredibly grateful for the Foundation's continued generosity and support, without which this wonderful event would not be possible. It is now my distinct honor and privilege to introduce to you our 112th Sibley Lecturer, the Honorable Janet Napolitano, President of the University of California. President Napolitano's numerous accomplishments throughout her academic and professional life are nothing short of breathtaking. She received her BS degree in political science from Santa Clara University, where she was elected to Phi Beta Kappa, selected as a Truman Scholar, and was the university's first female valedictorian. 4 years later, President Napolitano earned her JD degree from the University of Virginia School of Law, and upon graduating, served for a year as a law clerk to the Honorable Mary M. Schroeder, judge on the U.S. Court of Appeals for the Ninth Circuit. After that, she spent the next 10 years practicing law as an associate and partner at the law firm of Lewis and Roca in Phoenix, Arizona. In 1993, President Napolitano embarked upon an illustrious career in government service, commencing with her appointment as the U.S. Attorney for the District of Arizona. In 1998, she was elected Attorney General for Arizona and remained in that post until 2003, the year in which she was elected Governor of Arizona. President Napolitano was re-elected in 2006 and served until she was tapped by President Barack Obama to become Secretary of the U.S. Department of Homeland Security, a position that she held from 2009 to 2013. On July 18, 2013, President Napolitano entered academia at the very top when she was named the 20th President of the University of California, a university system with 10 campuses, over 234,000 students, and an operating budget of $24 billion. Her extraordinary career has rightfully landed her on Forbes magazine's list of the most powerful women and spawned speculation that she could one day be the person who appoints the Secretary of Homeland Security. Ladies and gentlemen, the Honorable Janet Napolitano.
Well, good afternoon, and thank you, Dean Brown, and thank you for such a warm and welcoming introduction. I'm truly honored to be here today. As has been noted, it was 50 years ago, in the fall of 1964, that Professor Myers McDougall of Yale delivered the inaugural lecture of this series, addressing the somewhat expansive theme of jurisprudence for a free society. So to be able to participate in this milestone moment makes the honor of giving the Sibley lecture even greater. I should add that when I consider the quality of the speakers who have delivered this lecture in previous years, I'm more than a little bit humbled. Many of the greatest legal minds in the land, true giants, have made the pilgrimage to this podium to participate in the John A. Sibley Lectureships in Law. Richard Posner on the right of privacy, Arthur Miller on the emerging law of the internet, Ruth Bader Ginsburg, before she was elevated to the Supreme Court, on judicial activism, Anthony Lewis on the sins of the press. How he managed to keep that to 45 minutes, I don't know. But Justice Scalia on the Constitution, Judith Resnick, Cass Sunstein, Ed Muskie, H.L.I. Hart, the list goes on and on. More often than not, these lectures address, through the lens of law, critical issues of the day. Some 4 decades ago, for example, former Chief Justice Earl Warren came here to discuss the crisis created by the Watergate scandal, which by that point had moved to the televised hearings that riveted the nation. I was in 8th grade at that time, and I can still hear Barbara Jordan in that deep, dignified voice of hers, slowly, almost reverentially, rolling out the words, "Constitution of the United States." Looking back, it was the initial spark that would grow into my own personal passion for public service and politics. Warren was worried about what Watergate might portend for the future of the country. He said in his Sibley lecture that listening to Nixon's enablers testify had persuaded him that the nation was failing to instill in young Americans a sense of the moral values required of those who would assume positions of public leadership. His theme is interesting to me, and as future lawyers, it should be of interest to you. And before I leave here today, I want to return to it. Now, 5 years ago, University of Virginia scholar Frederick Schauer framed his Sibley presentation as a provocative question. Quote, "When and how, if at all, does law constrain official action?" It's a topic Professor Schauer had explored in depth from many angles and for many years. And in his Sibley lecture, he raised a host of additional provocative questions. Do public leaders pursue bold courses of action because of the law, or do they do so in spite of it? Or as he put it verbatim, quote, "When do various bureaucrats enforce the letter of the law, and when do they take the position that sensible interpretation and enforcement should trump faithful obedience to laws, rules, and regulations as written?" End of quote. His view is that such questions deserve greater inquiry, suggesting that, quote, "Public law ought to be interested in the empirical question of when and whether, if at all, officials follow the law, when doing so would be inconsistent with their own best of all things other than the law considered judgment about what to do." End quote. Now, Schauer's exploration of this topic was finely nuanced at every turn, and I would do him grave injustice to oversimplify it. Although I will say, and I don't doubt the professor would agree, that what we are dealing with here is not an either-or proposition. In law and in political leadership, the equation is never that easy. Still, Schauer's scholarly presentation got me thinking about what benefit I could bring to the podium today. And it occurred to me that it might be helpful to walk you through a personal account of the practical interior process that produced a decision that has made a difference in the lives of hundreds of thousands of young people. I'm talking about immigration and about an executive decision made in the first term of the Obama administration. I'm talking most specifically about deferred action for childhood arrivals, an initiative that was developed under my direction while I served as Secretary of Homeland Security. This was an initiative that required a careful navigation between the potentially conflicting dictates of doing what is right, doing what is lawful, doing what is doable, and in doing what is defensible, both in the court of law and, to a lesser degree, the court of public opinion. Before we push off, however, I want to carve out an important caveat. My commentary will be contained exclusively to my time at the helm of DHS and to the specific decision to move forward with what we call, in Washington's fondness for acronyms, DACA. This is an election season, I think you've probably noticed, and immigration policy and DACA are still very much in political play. So let's be clear. Today, I do not intend to present any fresh insider knowledge into how these issues will be sorted out going forward. My mission hews more toward the historical and the mechanical, to explain the decision-making process on a consequential and complex national policy matter. Along the way, I would like to suggest that a well-developed working knowledge of the law is essential in determining, as a public sector leader, what you can and cannot do in the pursuit of what you believe is right. So let me begin with a few lines from T.S. Eliot's poem, The Hollow. Between the idea and the reality, between the motion and the act, falls the shadow. The story of immigration policy in this land, including the development of DACA, is a story of shadows and shades of gray. It is no area for absolutists. The policy that became DACA is rooted in a subset of young immigrants who, through no fault of their own, found themselves living in the shadows of American life. Sons and daughters of undocumented immigrants, they had been brought into this country as children. They were kids who stayed out of trouble, who went to school, who in all but the letter of the law were Americans. Some never even spoke the language of their native land. Many went on to college and were extraordinarily successful, from serving as student body presidents to attending law school and passing the bar. They would come to be called dreamers after the proposed DREAM Act legislation, first introduced in 2001, which would have given these young people legal status and a path to citizenship. By 2008, there were an estimated 1.4 million dreamers living in this country. And whatever their personal accomplishments, all dreamers lived in fear of deportation. And all endured an existence of everyday difficulties unknown to their American-born contemporaries, unable to secure driver's licenses, work permits, or Social Security cards, unable to receive federal loans for college, or after graduation to pursue their chosen professions. Now, when President Obama came to the White House, immigration reform was a priority. However, we knew it would be difficult. The Congress was just a few years removed from the failed attempt at comprehensive reform by President Bush, who deserves a lot of credit for taking this issue head-on, by the way, along with liberal icon Senator Kennedy and my home state Senator John McCain. President Obama asked us to push forward. However, with the economy at rock bottom and with the fiscal stimulus bill and health care reform emerging as urgent issues for the president, the early momentum toward meaningful immigration reform stalled. It became increasingly clear that comprehensive reform was not going to come fast, and it was not going to come easy, if at all. That's politics, and the politics of immigration have always been arduous. We like to joke or half-joke at DHS that if both sides were kicking us with equal vigor, well, then we must be doing something right. This was brought home for me starkly on one occasion when I was testifying before the U.S. Senate Judiciary Committee. I was seated alone at the witness table when Republican Senator Jeff Sessions began criticizing DHS for, in his view, not enforcing immigration laws vigorously enough. That same moment, a group of protesters stood up in the rear of the hearing room. They began shouting and waving signs that said DHS was enforcing the immigration law too vigorously. I was caught in the middle. This experience, and many others like it, highlighted that all too often immigration policy and the debate that envelops it resemble a washing machine at work. Load, inject soap and water, churn, also known interestingly as agitate, rinse, drain, spin, repeat. The main difference is that in the immigration realm, we never seem to graduate to the dryer. We just do it all over again. Now, as a former U.S. attorney, attorney general, and governor of a border state, I knew that many of our immigration enforcement policies made little, if any, sense. This became even more apparent in late February 2009, in only my second month as secretary at DHS, when immigration and customs enforcement agents raided a motor manufacturing plant in Bellingham, Washington, rounding up for 28 otherwise law-abiding workers who were in the United States unlawfully. I didn't learn about this raid, the first such operation of its scale since President Obama took office, until after it occurred. The raid underscored real questions that I had been thinking about since being sworn in. How do we prioritize and use immigration enforcement resources responsibly? For example, would it be more sensible, not to mention fair, to focus our attention on the employers who hire undocumented workers rather than the workers themselves? The answer to that immediate question came in the form of a new program of worksite audits. These were intended to put employers on notice that when it came to the legal status of their employees, they bore responsibility as well. But the need for setting priorities extended beyond worksite enforcement issues. Consider this. The United States Congress appropriates resources specifically to DHS removal and detention operations to remove less than 2% out of the 11 million individuals estimated to be in the United States illegally. These numbers imply that at an operational level, in the field, choices inevitably were being made about who should be removed, raising a host of important questions for us in leadership. Where should immigration resources be deployed, and to what end? Should we and could we set priorities that made distinctions between dreamers and say undocumented aliens who commit felonies or repeatedly flout the rules at the border. And if enforcement priorities were to be set, where and with whom did the authority reside to set them? With Congress, which makes the laws governing immigration? With the President and his appointees, including cabinet secretaries, who are constitutionally bound to take care that the laws be faithfully executed? Or, for that matter, with field agents who are sworn to uphold the law? Enter the lawyers. In my experience, when it comes to developing new approaches to existing problems in government, the considerations of policy and the law travel in tandem toward that same goal, perhaps, but with different calculations. You can't make a decision about what is the best policy based solely on the law, and you can't make a legal decision based solely on policy preferences. Yet, at the same time, policy and law are entangled within the decision-making process, and both are moving targets. Now, this is not a novel idea, this idea of entanglement between law and policy. A half-century ago, in the inaugural Sibley lecture, Professor McDougall actually lingered on this point. He said, quote, "Too frequently, law is still thought of as something that's written in a book, as rules on a piece of paper, or the words that come to us in 1787. On a deeper level of understanding, we know that this conception of law as a body of rules is hopelessly inadequate. Whatever our roles," he added, "whether we are judges, other officials, effective power holders, advocates, scholars, or simply members of the community, we are interested in more than rules. We are interested in decisions, what's done, the consequences of the making and application of rules for human beings." End quote. Now, as we assumed the reins at DHS, we began to grapple more and more with decisions and consequences in the immigration arena. Through the Director of Immigration and Customs Enforcement, the acronym is ICE, we had issued a series of memos to agents in the field. We instructed them to focus their enforcement efforts on the, quote, bad actors. This meant individuals who presented risks to national security or who had committed felonies, who had joined gangs, and those folks would be the focus of our efforts. Similarly, to preserve the integrity of the border, we moved resources to focus on recent border crossers. Finally, we instituted a case-by-case review of every deportation matter pending in the nation's immigration courts to see whether we could expedite the cases of those we wanted to remove expeditiously because they fit our enforcement priorities. And as for military veterans, longtime law-abiding residents, nursing mothers, people with certain family ties, the severely ill, and yes, individuals who might be called dreamers, the memos made clear that these no longer fit our priorities. Now, we neither could nor would ever tell immigration enforcement agents that they should stop enforcing immigration laws. But we certainly could tell them how to prioritize enforcement efforts given the limited resources that Congress provided the department. Implementing policies to direct how law enforcement agents go about their jobs, what is known as prosecutorial discretion, is as common as law enforcement itself. Now, we're all familiar with prosecutorial discretion because we experience it every day. We see it when police officers choose who to pull over for speeding instead of stopping every individual who drives over the speed limit. We see it when state environmental protection agencies decide what factories to inspect instead of sending agents to every factory in their state that could be releasing pollutants. And we see it when the IRS sets priorities about how to deploy its audit resources, instead of auditing every individual it suspects of being less than fully forthcoming on his or her taxes. Now, on a personal level, I myself had long exercised prosecutorial discretion, both as a former U.S. attorney and as a former state attorney general. The Department of Justice, for example, does not focus on small bad check cases, even though bad checks violate federal law. But the U.S. Department of Justice has bigger fish to fry. Now, prosecutorial discretion has a long and distinguished history in immigration law, and so we were confident that we were on solid legal ground when it came to setting priorities for immigration enforcement efforts. Our attorneys had done a great job exploring the issue, sifting through the precedents, pursuing legal questions that range from constitutional authority to congressional intent to the legal definition of the word shall, which is not, by the way, the same as must always. We continued with various rates of success to focus law enforcement efforts throughout the course of the first term. And just before the first midterm election of 2010, the House of Representatives passed the DREAM Act, which gave legal status and a path to citizenship to the nation's dreamers. Unfortunately, the legislation was filibustered by the U.S. Senate. It failed to reach the required 60-vote supermajority it needed by just 4 votes. But based on my conversations with lawmakers at the time and through the course of the next year, it was clear to me that a bipartisan majority of lawmakers agreed that dreamers were different. Of course, many lawmakers would not admit this publicly, but there was a noticeable shift in the tenor and tone of their comments where dreamers were concerned. So over the next 18 months, we began to build out our legal and administrative foundation for launching DACA. A key element was the U.S. Supreme Court opinion in Heckler versus Cheney, a seminal 1985 case involving the FDA's authority to exclude or allow certain drugs to come to market. In that case, the Supreme Court had ruled that, quote, an agency's decision not to prosecute or enforce, whether through civil or criminal process, is a decision generally committed to an agency's absolute discretion, end quote. Heckler also had addressed the need to align priorities and resources, stressing that an agency, quote, is far better equipped than the courts to deal with the many variables involved in the proper ordering of priorities, end quote. Another key element in our analysis was the Supreme Court's 1999 decision in Reno versus American Arab Anti-Discrimination Committee, where it explicitly recognized the executive branch's authority to exercise prosecutorial discretion in the immigration context. So the law, we believed, was on our side. Bureaucratic momentum was not. DHES was a new entity, a vast department that brought together many distinct agencies in the aftermath of the attacks of 9/11. Our earlier call for a review of backlog cases and removal proceedings through the lens of our stated priorities helped a bit, but in the end, it didn't have the desired impact. The dreamers remained in limbo, ensnared within the sputtering debate over immigration reform. And so it came to pass that in the spring of 2012, I assembled a small team of advisors, including our brightest lawyers, and I asked them this: what can we do about the dreamers? What can we do short of blanket amnesty? What can we do within the parameters of the law? The team's initial recommendation to me was limited to identifying dreamers already and actually in removal proceedings and granting them deferred action. I responded that this was neither big enough nor bold enough. The vast majority of young people who were dreamers were not in proceedings. They would still have to constantly look over their shoulders to see whether ICE agents were about to pick them up. I wanted to create a potential pathway to deferred action for all dreamers, not just those already caught up in the system. Here, I should explain that in immigration speak, the term deferred action generally means to suspend moving forward with certain cases for a fixed period of time. It does not mean granting amnesty or otherwise permanently resolving immigration status, but it does permit someone to live free from fear of deportation. It does permit someone to obtain authorization to work, which is so important for young students. Now, to apply deferred action in the form of a categorical exercise of prosecutorial discretion to an entire group across the board raised serious questions. It would run the risk of appearing to make law and usurping Congress. Thus, it would be crucial, both legally and politically, to underscore that each case would be assessed individually on its own merits, similar but not identical to how a prosecutor decides to charge a case. The dreamers would be required to individually step forward and apply for deferred status. As it turned out, some would be wary of leaving the shadows. What one administration might give, they reasoned, another might take away, and they would have left themselves exposed. All applicants needed to pass background checks. Those who qualified would be eligible for work authorization pursuant to a long-standing regulation that granted such eligibility to those who received deferred action. Now, at this point, I could not say with any degree of certainty that we would be able to pull off this approach. Individualized review of potentially hundreds of thousands of cases would require building complex new systems and processes within the existing bureaucracy. A daunting challenge. Who knew how it all turned out? What I did know was that it was the right thing to do. What I believed was that it was lawful. And while it would be a heavy lift, I expected it would be doable and, in the end, defensible. So we moved forward. The first challenge was defining precisely who would be covered by the new approach. As I mentioned before, our goal was to provide individuals who had come to the United States as children, develop deep roots in this country, and become productive members of their communities with relief from the fear of deportation. Translating that goal into the specific criteria that would be used by DHS personnel on the ground as they implemented DACA required careful consideration and design. To capture that DACA was intended to apply to young people who came to the United States as children, we required that an individual have arrived in the United States before turning 16 and be under the age of 30 on the date DACA was publicly announced. To reflect that those who received deferred action should have strong roots in the United States, we required that to be eligible, individuals must have lived in the United States for 5 years prior to the implementation of DACA and be present in the United States on the DACA announcement date. And to ensure that recipients of DACA were productive members of their communities, we required that to be eligible, individuals must be currently in school, have graduated from high school, have obtained a GED, or be a veteran and not have a serious criminal record or pose a threat to public safety. We felt these criteria accurately captured the individuals, the dreamers, that we wanted DACA to reach. The next struggle was internal. There were serious logistical concerns at the United States Citizenship and Immigration Services, USCIS, the agency of our department that would bear the brunt of responsibility for implementing DACA. One of USCIS's primary concerns was that we could not implement this decision given the size of the population we expected to seek relief. Now, as an executive, it's important to listen and to listen well, but it's also important not to conflate listening with agreeing, nor to let it stall important action. By 2012, I thought USCIS was prepared to deal with the needed administrative machinery to make DACA work. By the way, that's not something I could have said earlier in my tenure as secretary. So we pressed ahead and presented our proposal for DACA and its implementation to the White House. At this stage, the White House asked us to walk them through the legal rationale and the implementation challenges. The scale of our proposal was significant, perhaps more significant than any previous exercise of prosecutorial discretion, especially in the immigration context. Our White House colleagues asked serious, tough questions along several dimensions. We had many conversations and went back and forth several times. Eventually, they reached a comfort level with our legal position. DACA was well within the legal authority of DHS and with our preparations for implementing DACA across the country. Now, we knew there would be legal challenges. We were 99% sure we would prevail, but there were still some risks. Nonetheless, leaders who wait for 100% certainty of success before making a decision, whether in a legal, political, or operational sense, they're still waiting. You're never going to get 100%. So again, we pressed ahead. On June 15, 2012, I issued a memorandum to the heads of the DHS agencies that enforce immigration laws, handle immigration benefits, and police our nation's borders and ports. By this memorandum, it began, I am setting forth how, in the exercise of our prosecutorial discretion, the Department of Homeland Security should enforce the nation's immigration laws against certain young people who were brought to this country as children and know only this country as home. Additional measures are necessary to ensure that our enforcement resources are not expended on these low-priority cases, but are instead appropriately focused on people who meet our enforcement priorities. End quote. Anticipating accurately that some members of Congress would howl, I closed the memo with the following, quote, this memorandum confers no substantive right, immigration status, or pathway to citizenship. Only the Congress, acting through its legislative authority, can confer these rights. It remains for the executive branch, however, to set forth policy for the exercise of discretion within the framework of existing law. I have done so here. End quote. On the same day my memorandum was issued, President Obama announced DACA from the Rose Garden. This was a significant action by the president. It put the authority of the presidency and the White House solidly behind our departmental efforts, and it gave us great confidence as we move forward. With DACA launched, it was now time for us, and make no mistake, this was all hands on deck, it was time for us to wade into the hard work of putting together a deferred action program on a scale never before seen in the annals of American immigration policy. There were rules to be written. They ranged from who would be eligible to what documents would satisfy the proof of qualification to what new government forms would be needed. By the way, we converted existing government forms. The amount of the application fee, how the application fee would be processed, what the processes would be for reapplying. These two needed to be determined. Crucially, DACA needed to be self-supporting, which meant that the fee generated had to cover our administrative costs. And finally, we needed to set in motion an organized effort to get the word out about DACA, not only to our own offices, but also to communities of interest across the country. All of this had to be thought through, put to paper, and of course, run by the lawyers, every sentence, every clause, every word. And oh yeah, we had committed to being ready to begin receiving applications in 60 days, just to add a little more excitement to the exercise. So how did it all turn out? We received what appeared to be early support for our efforts in a decision by the U.S. Supreme Court that came less than 2 weeks after our DACA announcement. Although the issue before the court in Arizona versus United States was Arizona's restrictive immigration enforcement measures, the court's opinion contained language that was directly on point to what we had done in DACA. Justice Kennedy wrote for the majority that, quote, "A principal feature of the removal system is the broad discretion exercised by immigration officials. Federal officials, as an initial matter, must decide whether it makes sense to pursue removal at all." End quote. A dissent read from the bench by Justice Scalia suggested that the DACA announcement was actually on the justices' minds when they were in the final stages of drafting the Arizona opinion. Nonetheless, shortly after DACA went live, we faced a legal challenge. This lawsuit, brought by a handful of immigration agents, challenged our theory of prosecutorial discretion. The agents argued, in effect, that DACA required them to break the law. Now, how a law enforcement officer could confuse an effort that would enable them to focus their work on the true bad actors as compared to dreamers with a requirement that they break the law remains a mystery to me. Nonetheless, that was the position of some of our own agents. I should say, however, that the vast majority of ICE agents dutifully executed on DACA, and notwithstanding the objections of a few of their colleagues, conducted themselves professionally and responsibly. A district court judge in Dallas surprised us and most legal scholars familiar with the issues by ruling that the ICE agent's case might have merit. He then dismissed it on the grounds that it belonged in an administrative setting, not in federal court. That decision has been appealed and is now pending before the Fifth Circuit. Also predictable was the criticism that came from corners of the Congress. To hear our congressional critics tell it, DACA was both an open invitation for young people to illegally cross our borders and a constitutional power grab in the form of an executive amnesty program. It was neither. Rather, DACA has managed, in my less than objective view, to hit the sweet spot in public service. DACA is no substitute for comprehensive immigration reform. And that's why I've never stopped advocating for comprehensive reform. I advocated for it as Arizona's Attorney General and Governor. I advocated for it every year I spent as Secretary of Homeland Security. I advocated for it at the time we launched DACA. I advocated for it in the years afterwards, and I advocate for it to this very day. But in the absence of action by the House of Representatives on comprehensive immigration reform, something at least needed to be done to address the plight of the dreamers. Our answer to that challenge, DACA, was the right thing to do, the lawful thing to do. It was doable, and it was defensible. In the 2+ years since DACA was launched, after what the New York Times has described as a superhuman bureaucratic effort, more than 675,000 young people who were already in this country have come out from the shadows. Legally and in the light of day, they have applied for and received deferred status, work authorization, and other previously forbidden pieces of paper that had dogged their day-to-day existence. They're people like Mario Leo, who was brought here from Peru at the age of 12. He received his education in civil engineering at UC Berkeley. Go Bears. But given his immigration status, he was unable to pursue a professional career, let alone apply for a driver's license or social security number. DACA changed all that. So many doors opened overnight, the 25-year-old told the Wall Street Journal. I became a new person in some ways. Mario Leo now works as a project engineer for the firm that built Levi's Stadium, the new home of the San Francisco 49ers. Multiply his story by almost 700,000, and you get an understanding how much of a difference DACA has made. And here, on the matter of making a difference, I would like to conclude my remarks by stepping away from the DACA narrative and addressing on a more personal level all the prospective lawyers in this hall. In so doing, as promised, let me return to the Sibley lecture given by Chief Justice Warren amid the wallow of Watergate. The national mood, the retired Chief Justice just said in this setting 41 years ago, is leaning toward a cynicism that interprets these derelictions as being the norm of public life, and that certain people in present circumstances just happen to be caught. In particular, Warren voiced concerns about the country's ability to educate the kind of capable, moral leaders required for public service, and to encourage them in a scandal-weary era to follow that path. I'm now in the education business. I could not agree more that it is a fundamental obligation of universities, especially public universities, to grow future leaders who will look beyond their own careers and dreams of lucrative careers and consider the possibilities of public service. So let me offer some encouragement toward that end. In this audience, I see a lot of future lawyers. I see future lawyers who I know, given their Athenian education, go Dogs, will go on to great success in the profession. What I hope to see, what I want to see, and what our country needs to see are talented young lawyers who will answer the call to public service. Now, make no mistake, a private sector career is nice, and hey, a healthy paycheck is a wonderful thing. But I will stand here today and say this with utmost certainty. In the end, how each and every one of you comes to judge the success of your life in law will hinge on your answer to a single question. Did I make a difference? There are many ways to make a difference, both within the legal profession and without. But as my narrative suggested, I hope, for those who possess a legal background, there are opportunities in public service to obtain rewards that transcend the size of the paycheck. There are opportunities, if you know how to apply law to policy and policy to purpose, to make a difference. And anytime any of you would like to talk to me in greater detail about making a difference in public service, I'm all in. Thank you for your attentiveness and for your Georgia hospitality. Thank you for the honor of participating in this wonderful series of lectures, and I hope learning. And to quote the motto of the University of California, Fiat Lux, which is Latin for let there be light. Thank you very much. I think we have time for a few questions. Here is your Oprah moment. There's one in the middle there. There's questions right there, so let's get the mics up, please.
Shifting gears a bit on the subject, as the president of such a large university system, do you have any protocol in place to deal with such a challenge as the Ebola outbreak?
Yes, actually. We have a protocol in place in our hospitals. We run 5 academic medical centers. We have a protocol in place for members of our medical school faculties who go to West Africa and want to return. And we are the regional medical centers for the entire state of California, where Ebola is concerned.
And a quick follow-up. Do you see any chance in the foreseeable future of us not having to go through the security lines at airports?
No, and I'll tell you, just so you know, in terms of persistence and consistency of threats, the aviation threat was the most constant during my tenure as secretary. So we've tried to do some things to take some pressure off the lines, like pre-check, which helps a lot, but no, those security requirements, I think, are here, unfortunately, to stay. I think there was a question in the middle here.
Yes. I'm an employee of this university, and I'm also have been able to find a way to work with undocumented students. Many of them had benefited a lot from the DACA program, and I thank you for that. But as you might know, there is a policy in this university that is part of the university system in Georgia that does not allow them, does not give them admissions. Undocumented students, even if they have DACA, they cannot be admitted to a university like the University of Georgia, even if they had been in high school in the same town. Mm-hmm. So my question is if you can, in the less, as you said, less than objective opinion, if you can tell us why is